There, I think we are ready to go. So I just want to welcome everyone to the 5th annual Indian Law and History Lecture at Maine Law. We're very excited about this. I'm going to introduce myself, and you may think that I am Lee Softly, Dean and President of the University of Maine School of Law, but in fact, I am today Anthony Moffa. Have you noticed I'm taller? And I'm a little bit crazier. He is on screen, so he's going to hear me say anything else that I would say. So welcome me as Professor Moffa. The real Professor Moffa, are we seeing him? I don't think we are yet, but you will see him later, has just returned from Brazil, where he and several Maine law students attended the Conference of the Parties, number 30, in which scientists, lawyers, negotiators from across the globe gathered to consider priority actions needed to address climate change. And I am so grateful to Professor Moffa for all of his work and his willingness to travel internationally in this chaotic travel environment. So, just as we were all relieved to know that Professor Moffa and all of the students with him had returned safely from Brazil, we learned that along the way, the good professor picked up COVID, which is why you will see him on the screen, not here in person. Everybody send their best wishes for quick recovery. It is my honor to be here today to welcome you all to the annual Indian Law and History Lecture. And I begin today by acknowledging that the land and water that we occupy here are a part of the Dawnland. These lands, some of which are actually reclaimed from the ocean, and I believe we are standing on a part of those lands that have been reclaimed, were the ancestral fishing, hunting, and agricultural grounds inhabited by the Abenaki people for thousands of years. In addition to the Abenaki, the broader place we now call Maine is home to the people of the Wabanaki Confederacy, the Penobscot, Passamaquoddy, Maliseet, and Micmac peoples. We remain grateful for their stewardship of these lands. And I want to thank everyone who has supported this important Indian law programming at Maine Law, especially the Tribal Nations Law Practice Group at Drummond Woodsum, many of whom are in the audience today. Thank you for being with us. This year's lecture is titled Protecting Indigenous Intellectual Property, and it will be jointly delivered by Professors Trevor Reed and Jane Anderson, who are not only experts in the field, but artists in their own right. If you've not had a chance to experience Jane's film or Trevor's music, please do so after this lecture is over. In addition to his JD from Columbia University, Dr. Trevor Reed, who sits at the left over here, assisted by Margaret, who is waving to all of us. Dr. Reed holds a PhD in ethnomusicology from the same institution. His work as a composer and as director of the Hopi Music Repatriation Project has promoted and protected Indigenous music. Dr. Reed's legal scholarship examines how the appropriation of indigent peoples' creativity and cultural data affects their sovereignty today and what opportunities currently exist to address these impacts. Maine Law is honored to have him join us in person to deliver his portion of this year's lecture. I'm also going to introduce Dr. Jane Anderson so that I do not interrupt the conversation. Dr. Anderson joins us from their post at NYU Law School. Dr. Anderson's research focuses on the philosophical and practical presentation by intellectual property law for the protection of Indigenous traditional knowledge, resources, and cultural heritage. Dr. Anderson is also a founding member of Local Context, a nonprofit organization that provides strategies for navigating copyright law and help developing new options for Indigenous control over intellectual and cultural properties, vital cultural heritage, environmental data, and genetic resources. Recently, they collaborated with the Penobscot Nation to create the film They Returned Home. Please make sure you watch that. We are honored to have Dr. Anderson join us virtually this afternoon. And at this point, Dr. Reed, the floor is yours.
Well, thank you, Dean. It's wonderful to be here. It's wonderful to be here on Wabanaki lands, and I'm grateful for all of you that have joined us today. We have quite a bit to talk about today, but I first wanted to introduce myself in my native language. Nup ba huaitiwa yan matsiwa, put nu Trevor Reed yan pahan matsiwa, no hot vela kitokinawi onk, and nu halai itam uki. I'm really grateful to be here, and I'm happy that you've all decided to come and take your time to learn more about Indigenous intellectual property. Professor Anderson and I have worked together for many years, and so we're excited to be able to share kind of a joint and a collaborative view of how the field of Indigenous intellectual property has been progressing and developing, but also to make a point, right, that we need more Indigenous intellectual property legislation. We need more people skilled in both Indigenous law, and also we need folks that are skilled in intellectual property to come to the table and help tribes to defend the things that are perhaps the most important to them, in addition to our lands and our waters. So I'm going to go ahead and step back for a second, and Professor Anderson is going to kick us off with our lecture. But I'm looking forward to hearing your thoughts and your questions at the end of the lecture, and I'll be chiming in here and there. So Jane, I'm going to go ahead and turn the time over to you.
Hi, everybody. I can't really see you, but I am here and I'm calling in from Lenapehoking, the lands of the Lenape Nations. It's really exciting to be part and to be invited to be part of this lecture. And I'm just going to share my screen and jump right into it. Can you see that, Trevor? Can you let me know if that's working?
Yep, that looks great.
Okay, great. So as Trevor said, we've been working in this field for a long time, but also together in different kinds of capacities. And so when we got this invitation, we talked to each other and we will be like, okay, how are we going to do this? Are we going to do the history? You're going to do history. I'm going to do the history. And then, you know, because of the work that I've been doing in Maine, contextualizing some of that, we decided actually to give a presentation together. So we're going to kind of dovetail and go through, you know, some of these key issues, and we are doing it a little linearly in the sense that we're going to talk a little bit about kind of early copyright and some of the challenges that Indigenous people face in relationship to that body of law. So we just wanted to kind of start off, you know, a lot of folks in US law schools kind of taught that the copyright really begins in the Constitution of the United States, but it begins before that. And it's kind of important to understand that some of these key events like the Statute of Anne and also the literary property debates in the 1700s in England and Scotland really start the development of what we currently know as copyright. Copyright, super interesting area of law, obviously, but what's interesting about it is it has actually retained and regained power since the 17th century. It's really interesting how, you know, the questions that we're dealing with AI at the moment developed in also kind of the 1700s as these questions of who is an author and what is an original work were kind of thought through. So it's also, I think, really pertinent to note that all 13 colonies had copyright legislation prior to the Constitutional Convention in 1787. This is partly why we see that the Constitution has provision for both copyright and patents. I think that just that interesting history tells us a lot about that copyright was actually really important in the colonies because it was about printing, controlling the circulation of knowledge, and kind of that we see that it doesn't just arrive in the Constitution out of nowhere. Importantly, this also kind of tells us a little bit about its colonial origins, right? We're going to talk a little bit about how intellectual property does not work for Indigenous communities, or it's never developed for them. And this is partly, it's embedded in the different kinds of influences in relationship to the development of copyright. So we obviously have Locke and Blackstone and Jefferson. And importantly, they're all linked together in informing the shape of US copyright, especially in terms of Locke, developing the concept of labor, which replaces occupancy as title in land, and subsequently ideas. Blackstone's role in reframing the category of the author and his seminal definitions of originality. These are two key categories that continue to inform the identification of what a work is and how it is protected. It's also important to know that until 1976, there was dual state and federal copyright systems. The federal system of statutory copyright initiated in 1790 with the first copyright statute, protected registered works, while state copyright, initially created before 1790, maintained post, was common law copyright and protected unregistered works. And to receive either statutory or common law copyrights, there needed to be both an author and a work. And until joining the international system in 1891, that author also needed to be a citizen. So the focus on the citizenry provision is usually directed to what this meant for foreign authors and the loophole that US publishers identified, which facilitated the reprinting of books by foreign authors without their authorization or paying royalties. But there's also an overlooked internal consequence of this citizenry requirement for copyright, as neither Indigenous peoples nor enslaved African were held citizenship status. And this has obvious social, cultural, economic, and political consequences. So structurally, that very idea of the author and the author figure themselves is actually reinforced particular kinds of racial hierarchies. And within this hierarchy, the author receives and benefits from social and culturally endorsed recognition. The author is always named, the author's name is remembered, the author is attributed, the author is acknowledged, and the author becomes part of cultural memory. So if you don't get to be afforded the status of author, that's part of the problem that we're kind of dealing with today. And I'm going to hand it over to you, Trevor.
All right, thank you. Before I go into this slide, let me just see, how many of you have taken federal Indian law while you've been here in law school? All right, we have a few. Congratulations. How about copyright? Has anybody taken copyright while you've been here? Okay, so it's a little quiet on that side. Okay, so let me delve into this just a little bit. And you know, when we talk about federal Indian law and we talk about intellectual property, a lot of people feel like these are totally different fields. They have nothing to do with each other. But as you match up the timeline, you actually see that the two are very much intertwined. Whenever copyright changes, remarkably, there's a change in federal Indian policy as well. And so I wanted to go through some of these, just so you can see a little bit of what Professor Anderson was talking about, you know, how there are direct impacts and direct alignments between the two. So, for example, it isn't coincidental that we have the Copyright Act happening, you know, adding in music, for example, at the same time that tribes are losing their ability for foreign relations powers. Or later on, where you have the 1870 Copyright Act at the same time that we're having assimilation policies being imposed upon Indigenous peoples, all the way to the present. 2018 is the first time that the Copyright Office actually acknowledges tribes. And you know, we're still trying to see Congress do the same. So let me just walk you through some of these histories real quick. The first major revision to the copyright law was in 1831. And again, this was only months after the Supreme Court stripped tribes of their foreign relations powers and denied them access to the courts. Jane, go ahead and go to the next slide. So the big case here was Cherokee Nation versus Georgia. The federal government had passed the Relocation or Removal Act, using promises of money and land to Cherokee Nation to leave their homelands in the South and head out to what became Indian Territory and later Oklahoma. But for Georgia, this process wasn't fast enough. They felt like the federal government was stalling on them, and so they decided to go at it by themselves to expel the Cherokee Nation from that territory. And so what did they do? They passed laws annulling Cherokee's own laws, and they also sent settlers to go take over some of the territory as well. Um, Rather than rule against Georgia, the Supreme Court decided to actually question its own jurisdiction. And it decided to chip away at Cherokee Nation sovereignty in the process, calling tribes in general domestic dependent nations rather than foreign nations under US law. And that ruling meant that tribes no longer had access to federal courts without some kind of special congressional approval. So this led, of course, to the Trail of Tears and massive loss of life for Native peoples. So only months later, Congress decides to add musical works to the Copyright Act. But because tribal nations no longer had access to federal courts to defend their rights, they were not citizens of the United States, they had no ability to protect their musical works. Now, it's not that indigenous culture wasn't actively being consumed by the settler public, right? We know about the fraternal organization, the Order of the Red Men, had been founded in 1826. I know there's even chapters that are around this area, right? And they performed indigenous rituals and ceremonies. We also know Last of the Mohicans was written in that same year. And so people were interested in consuming indigenous culture. So it was a little bit remarkable that all of this could happen and then tribes lost their ability to go to court and protect their works. So, you know, this gap in copyright and federal Indian law allowed settler composers in particular to appropriate indigenous music. So let's move on to the next slide. So the 1870 copyright revision was another really landmark and transformational moment in the history of copyright law. Before 1870, you could just go to your local district courthouse and register your copyrights. And it was pretty straightforward. In 1870, Congress had the idea that they would start to construct an intellectual empire using copyright law. So now when you registered your copyright, you had to actually go to the Library of Congress, you had to send your stuff in, and then the Library of Congress started amassing this incredible collection of copyrighted works, making it the largest library in the world. Those who published their work but then didn't deposit it in the Library of Congress lost their copyright and they couldn't control the future of their work. Congress decided to also use a similar kind of an assimilationist strategy with indigenous peoples, lands, creativity in the next couple of years after 1870. The next year in 1871, Congress eliminated the ability for the executive and the Senate to enter into treaties with tribes. So treaties lost their ability to make, or tribes lost their ability to make treaties with the United States. And then it just kind of spiraled from there, right? 1884, the Supreme Court held that indigenous peoples didn't have the right to vote in federal elections. 1885, it imposed federal criminal law on tribal lands, where before indigenous peoples had their own criminal laws and enforced those. 1886, the Supreme Court invented a plenary power doctrine that said that Congress had supreme authority over indigenous peoples. And so you have no representation, Congress taking control of tribal lands. And just as a note, Justice Gorsuch and Justice Thomas just this week are calling for Kagama, that case, to be overturned. 1887, Congress passes the Dawes Act, where it starts to divide up tribal lands into individual parcels and allot those to individual tribal members and then sell off the rest of the land to settlers who want to move in. Congress then makes numerous acts authorizing federal boarding schools, where they're actually going to extract children from the homes of indigenous peoples and send them miles and miles away to be trained so they will lose their language and culture. Then 1890, federal officers start prohibiting ceremonies from happening on tribal lands, and that culminates in a ban on ceremonial dances in 1920. Keep in mind, all of this is happening at the same time that Congress is also authorizing the capture and appropriation of indigenous culture. 1868, the Surgeon General is authorizing the Army to go out and dig up indigenous bodies to be able to extract data from them to prove that indigenous peoples are inferior to white people. 1878, the United States establishes the Bureau of American Ethnology. And the idea is to go out onto tribal lands before the culture is lost, to document it and send it to museums so that people can be educated and enjoy indigenous culture while indigenous peoples themselves cannot. the early 1900s, federal laws like the Antiquities Act are passed. And the Antiquities Act says that tribal artifacts and also tribal sacred sites are the nation's federal property. And during that same time, indigenous sacred places are turned into national parks and national monuments, national forests, and national wilderness areas. So this notion of deposit, and Jane, we'll go to the next slide here. This notion of deposit is in fact happening with indigenous peoples. All of their culture is being expropriated and sent to institutions around the country. The problem is that indigenous peoples aren't getting the rights to control it, like every other member of the American public. No wonder why indigenous peoples want these materials back, right? Why they're calling so vehemently for repatriation and want the kinds of protection that they deserve. All right, Jane, back to you.
Yeah, so as Trevor so clearly lays out, these relationships between policy and copyright and the consequences of that are really profoundly felt. On one hand, we've got the kind of collecting and consuming of Indigenous culture for non-Indigenous people. And we have the policies that are developed that are actively harming and creating violence against Indigenous peoples. And these are legacies that we continue to deal with within kind of both federal Indian policy, law, and also copyright. So just an example of how this might have affected places like Maine. This is the Passamaquoddy wax cylinders that were actually the first recordings that were ever made on tribal lands in the United States in 1890. They went to Harvard University. They disappeared from Passamaquoddy spaces. They didn't know where they were. They were not returned until in the 1970s, and then in 2025, when the technology became better to listen and to understand what was on these recordings. This is a catalogue record from the Library of Congress that demonstrates a real problem in relationship to the provenance and the attribution in relationship to many of these recordings. So that list that we just showed of all the amounts of collections that have come from Indigenous lands, often they have really poor information that sits with them. Not only community names missing, but also so are the names of the singers and the songwriters and the dancers and the people in the photographs. And this makes it for a really big problem when you're trying to find those collections to get them back to communities. So this is an impoverished record, right? It looks, it's got very little information. The recordings themselves are in Passamaquoddy. And when we started working with Passamaquoddy to update these records, what Passamaquoddy wanted included was not only the proper names of the songs to be in the record in Passamaquoddy, but also the kind of history that Trevor is talking about. What was happening on Passamaquoddy lands and waters when these recordings were made in 1890? So this is an updated catalogue record after working with Passamaquoddy elders for over 5 years on what is actually on these wax cylinder recordings, and then adding certain kinds of rights back into the record. Now, this is very difficult because rights fields, or the kind of where rights normally sit, is the purview of the copyright holder. In this instance, it was Harvard University that claimed common law copyright over these wax cylinders that were made on Passamaquoddy tribal lands. And as we try to redress or to create strategies that can open that space for Indigenous rights to be included within those spaces, we find that it's really difficult to do so. This is the updated rights advisory after conversations with the Copyright Office and seeing that these rights should finally be included in the rights advisory. And you can see at the bottom, the rights are still held by Peabody Museum of Archaeology and Ethnology at Harvard, even though these are Passamaquoddy songs that Passamaquoddy in Passamaquoddy. And so what's happened over time is that Harvard now has agreed that these songs are rightfully held by the Passamaquoddy and have taken their name out of the rights advisory. One of the challenges that we find is also within the data infrastructures that hold these names also were created with no space for Indigenous authority and Indigenous rights as well. And so a lot of my work through the kind of organization local context is to bring those rights and responsibilities back into the data infrastructures themselves. And that takes years of work. I would say that it wasn't enough for Passamaquoddy to have an updated record in the Library of Congress. They needed those recordings to come home and for Passamaquoddy to assemble their own stories in relationship to the recordings. They also created a space for their own rights to be asserted. And this is a pretty important rights statement that was developed with Donald Soktoma from Passamaquoddy. It says, these recordings originate from the Pescomacati people, were recorded on our traditional homelands, and as such, the Passamaquoddy tribe maintains all legal rights to these recordings in perpetuity. We never ceded our inherent sovereign right to our songs, narratives, and language to any non-Passamaquoddy individual, institution, or government authority. So in this way, trying to reassert those rights that have been taken back into kind of not only popular space, but also cultural memory. Back to you, Trevor.
All right, thank you. So at the turn of the 20th century, kind of the time when Professor Anderson was just talking about, when those recordings were made, the United States was starting to evolve its thinking about copyright. There's an important case that was happening in the early 1900s. Because of immigration and new technologies, we had a diversity of art forms happening in the United States, and the courts and Congress were forced to reconsider who would receive copyright protection. Previous to this time, it was mostly, kind of the classical art forms, but this case, the Bleistein case, came before the Supreme Court. And in 1903, you had a situation where a circus master named Wallace had actually been sued by a competitor for copying the circus poster that this competitor had. And Wallace's attorney made the argument that, hey, this is not fine art, which is what copyright protects. This is low art, low class art. And so our argument is that it just doesn't deserve copyright protection. And Justice Holmes handily dismissed that argument in that decision. Basically adopted a non-discrimination principle prohibiting aesthetic supremacy within our copyright system. Now, Justice Holmes' decision could have paved the way for Congress and the courts to finally accept Indigenous culture as copyrightable and defend it. There was already at this time a lot of political activism happening, primarily led by white women's groups that were trying to prevent these assimilationist policies that were happening from harming Indigenous peoples. Tribal members were made U.S. citizens in 1924 as a result of some of this activism. Tribal nations received federal recognition beginning in 1934. Some tribes had been recognized prior to that. And so this was a really exciting time when this Bleistein case had been decided. So during this time of tremendous activism, the Copyright Act was again amended in 1909. But again, Congress missed a tremendous opportunity here to add another a broadening of copyright law. Instead of codifying Bleistein to finally include Indigenous and other minorities' creative works, it focused on making music even more easily accessible for appropriation. They included the compulsory licensing regime, where so long as somebody had published a musical work, you could actually go and make a cover of it. And that is now the law, right? Now, even if you own a copyright to a musical work and you've performed it, I guess, out there in the public or have released it to the public, somebody can just perform it without your permission as long as they pay you a royalty. So the music industry caught wind of this, and Jane, go ahead with the next slide. Caught wind of this, and Indigenous music seemed to be ripe for the taking. We had record labels signing deals with folks, sending them out to reservations to start recording them. This woman that you have here, Laura Bolton, the self-proclaimed music hunter, traveled to a lot of Indigenous communities around the world, including my own. And after entering into a record deal with Victor Records in 1939, she traveled to my homeland in 1940 to start recording. Now, my tribe had just adopted a constitution under the Indian Reorganization Act, but she came onto tribal lands flanked with 2 Bureau of Indian Affairs agents and started recording people, including our traditional leaders, Dan Kutsungva, David Manangya, and Thomas Banakya. And she recorded a variety of their ceremonial songs, including some songs that were restricted by our tribal laws. So after a day or two of recording, she stopped and headed home. We have no evidence that she ever paid these people. She certainly never entered into agreements to transfer their rights to the recordings to her. Her record deals and other papers showed that she believed she was the author of the songs. That was pretty remarkable. And there's no evidence to suggest that the tribes had ever authorized her to violate these ceremonial restrictions on this kind of copying of those materials. So under the common law rule of the day, and also under our tribal law, she was effectively infringing their copyrights. Lo and behold, 1941, this album comes out, Indian Music of the Southwest, and she begins to sell copies of this music. The contract with Victor Records shows her, they didn't even bother to ask her who these performers were, whether they had rights, right? Completely foreign to how people were treated back in that time, where performers' rights were quite important. Still, Victor commercially released these recordings, and here you have sonic racism at its best. So, this kind of appropriation continues on. We have World War II. Congress once again begins to push hard against indigenous peoples, terminating over 100 tribes in the United States using its plenary power. This leads to the struggle for indigenous civil rights in the 1960s. And then 1970 happens. And the unlikely hero, Richard Nixon, is the one that upholds indigenous self-determination. And you can see in this quote that he wisely links indigenous creativity and art to the development of the United States and its culture, lays out a plan for indigenous peoples to start controlling their own futures, right? Taking control of the federal services that are offered to them. So the Indian Self-Determination Act is passed in 1975. It initially allowed tribes to take control of programs offered by the Department of the Interior, Health and Human Services, and a few others, and gives tribes the funding to do these programs on their own without federal interference. Since then, it's been expanded to allow tribes to repackage these programs and kind of do it their own way. Well, the next year, 1975 turns to 1976, copyright is again revised and is a major overhaul of the Copyright Act. So with Nixon's words fresh on their mind and the Indian Self-Determination Act right there, we have again a revision of the copyright law that completely forgets indigenous peoples, right? Instead, it makes explicit several provisions that make it harder for indigenous peoples to receive protection. There's the fixation requirement now, it's codified in the act. It says that you have to actually write down or record the material in order for it to be able to be protected. Of course, a lot of indigenous culture is transmitted orally. Excluded pre-1972 sound recordings, all the ones that Laura Bolton and some of the others that recorded up here, excluded them from the federal coverage. Required registration with the US Copyright Office and deposit, just like it did in the 1870s, and it also codified several exceptions to the copyright laws, allowing people to use creative works when they want to transform them to serve a different purpose, or when there's maybe a public educational reason, they can actually use works without permission under the fair use doctrine. It would be another 40 years before the Copyright Office would finally acknowledge tribes in a meager sliver of the Music Modernization Act. So what do we have since then? Jane, on the next slide, we have cultural appropriations happening all the time, right? We've got, thank you, I appreciate that. We have, for example, Neiman Marcus, right? Ripping off a raven's tail coat designed by a very prominent indigenous artist from Alaska. We have Mad Happy, right? Using the Navajo Nation seal of all things, right? Their government seal, putting it on a sweatshirt. And then, of course, the Twilight series, right? My daughters are listening and watching that. And, they didn't realize until they saw the name, the Quileute tribe is mentioned in there and their stories and a lot of things. And then of course in the film, you got the tattoos that have the symbology, right? So all sorts of things are being appropriated. And about this time every year around Halloween, I get phone calls from the press. What do you think about the Pocahontas costume? Or what do you think about, and I'm like, why am I still answering these calls, right? Why don't we have better protection for our Indigenous peoples? All right, Jane, next slide. All right, so why does copyright fail? Well, scholars have been at this for a long time, so these are no secret. It requires creativity to be disembodied. That's one big problem. A lot of times Indigenous people share their culture in the body, right? They're either performing it or sharing it orally with each other, and that's to keep it grounded in the person. And so by excluding that form of transmission, you're excluding Indigenous people's creative practices. Copyright only protects works, right? It doesn't protect the material reality around performances. Indigenous peoples often want to control how, where, when, or by whom their culture is being used, and that unfortunately isn't easy to do, at least not by default under the copyright law. It turns creativity into private property, right? When Indigenous creativity often should be stewarded collectively. It privileges new creativity when Indigenous peoples often want to protect the oldest and they value it the most. It creates a distinction between ideas and expression, which even for copyright attorneys is difficult. When Indigenous peoples may see idea and expression as inseparable, and it excuses appropriation for that might be handy for artists and researchers when Indigenous peoples might have different values. So tribal nations deserve better. Congress has a duty of care to help tribes protect themselves and their assets. And so my argument is that Congress must pass copyright reform now. As we're coming up on 50 years since the last revision of the Copyright Act, now's the time for us to see these big changes. At the very least, we should allow federal enforcement of tribes' own intellectual property laws. And we'll show some of those to you in just a little bit. All right, Jane, back to you.
Great. So I also just wanted to add, before we kind of get into some of the examples that we've kind of been working on in Maine, is just some of these larger intellectual property developments in international spaces. This is kind of partly through and comes out of the Second World War, but particularly the revision of the Berne Convention in 1967. The inclusion of many more states post-World War II is kind of part of a decolonization work that had been happening within African states, to mean that there are many more votes that could happen within the World Intellectual Property Organization. This one nation, one vote really changed the status quo, and intellectual property no longer was controlled singularly by European states. This meant that in 62, 67, African states and Asian states wanted to see the development of this new category called folklore. The World Intellectual Property Organization was also developed, also established. And then we start seeing from 1976 onwards some small movements towards the recognition that there is a problem around Indigenous rights and intellectual property. In 2001, the Intergovernmental Committee on Genetic Resources, Traditional Knowledge and Cultural Expressions was developed, and that had been meeting for 25 years until just last year a new treaty was developed around genetic resources, particularly the disclosure of Indigenous interests in patent applications. So this kind of international environment also affected the inclusion of Article 31 in the Declaration on the Rights of Indigenous Peoples. This Article 31 is probably the best expansive framing of what really is at stake with Indigenous intellectual and cultural property. And it is much more expansive than our current legislation is able to include. But because it was developed through Indigenous activism and is based on all of these kind of historical experiences, we see that it includes technologies and seeds and medicines and cultural expressions and sports and designs. and that it's really about the control and protection of Indigenous intellectual property in a really different way. We have not seen that, of course, come into nation state legislation. We're starting to see it in places like Australia, and Canada are starting to develop unique what we call sui generis law in relationship to Indigenous intellectual and cultural property. But this kind of creates the bar that we're aspiring to get to. So I just want to spend a couple of minutes talking about some of the work that I've been doing in Maine, at least since 2013, on some of these kinds of questions. I first started working for the Penobscot Nation in 2013, really looking at ownership of the Penobscot Nation's language materials. They were held by a third party, also outside of Penobscot Nation, outside of Maine entirely, actually, and the American Philosophical Society, and working really closely with the tribe to determine who actually owned the copyright in the language materials. Since then, I've worked on developing the University of Maine and Penobscot Nation MOU that recognizes both the lands that the University of Maine is on, as well as the holdings of Penobscot collections, and actually actively working to bring Indigenous Penobscot Authority back into those spaces. We've worked on the Passamaquoddy sound recordings, been doing some work up in Arcadia National Park around sweetgrass gathering, also worked on the Wabanaki Studies curriculum in Portland Public Schools and who owns the content that has been provided in the Wabanaki Studies curriculum. But I'm going to focus here on the work that we did at the Degahgabimok Contact Station. So as you know, I hope some of you out there know, this is one of the most amazing buildings that has now opened and is up in Katahdin Woods and Waters National Monument. But it wasn't always going to be a contact station that looks like this. This is the statement that you'll see when you walk into the building, making a visual statement about the Wabanaki Indigenous intellectual property that's been shared within this building. Now, this is work that took 5.5 years and actually began with a little bit of a misstep, wherein the architect who was working on the building came to a Wabanaki group that had been put together and showed them his design, which was of colonial barns. And he wondered why the Wabanaki weren't so happy with that particular design. So we spent some time listening to Wabanaki narratives. This is Jennifer Neptune sharing some of the Glooscap stories. And he came back from that meeting with a new design, an inspired design from Jennifer's narratives of Glooscap, of the moose antler. And it was at that moment where the Wabanaki Council saw appropriation about to happen and felt that this was kind of something that they really needed to change the direction of where these inspired ideas were coming from, and also potentially change the direction of the project. So they called me, and we actually asked for the project to be put on hold until some training on Indigenous intellectual and cultural property and cultural appropriation had been done with the leadership of the project, as well as all the architects and all the visual designers, to kind of really understand what was at stake for Wabanaki in sharing their knowledge in this way within this context. This led to a foundational memorandum of understanding between the Wabanaki Council and Elliottsville Foundation regarding the development of the visitor contact station. And in this MOU, we dealt with things like attribution, proper attribution. We dealt with permissions. We dealt with signage. We dealt with kind of making sure that there was a proper consultation that was being put in place. And not just consultation, working towards partnership. And importantly, we also addressed benefit sharing. Who was really going to benefit from this building being in on Penobscot lands in Katahdin Woods and Waters? So this is a foundational document that we got to that then kind of shaped the rest of the project. It led to the possibility of a range of different artists contributing into this space where their work was actually protected. Concepts that we'd built into the MOU were then distributed into contracts, really kind of enforcing the cultural and intellectual property of the artists and the ideas that were being shaped in this building. This is Gabriel Frey. He's using a design that James Francis had done that is based on the double curves from each of the communities. This was then etched onto the wood by Gabriel Frey and is now the door handles for the building. The door handles themselves are shaped like when you kind of go and hold the doors as you're opening them, you're really touching Wabanaki designs. And you're also holding the way in which the brass has been cast is that you're holding onto a canoe paddle. So all these kind of components of the Wabanaki tradition was brought into this building in very deliberate and non-appropriative ways. If you haven't been to the building, I highly encourage you to do so. Probably it will now be in spring when it reopens. But we had to do things like protect the birch bark drawings that you can see on the side here. They were originally created by Joseph Tomar, but they're from 1890. But their kind of reproduction in this space also needed protection. You'll see around the building there's constant attribution to all the amazing artists that contributed, from Sarah Sockbasin to Geo Neptune to Shane Purley. Everybody is actually properly attributed throughout the building. But it's also about telling Wabanaki stories from Wabanaki standpoints. The floor itself was developed by James Francis, and it is a map of the Penobscot watershed. So again, this kind of sense of whose land are you on when you're in this building? And of course, this kind of led to some questions about how, when this building was being handed back to the National Park Service, how do we work to protect the intellectual and cultural property that's been shared in the process of making this building? And this is where Corey and I worked on the agreement for all the tribal nations in relationship to the protection of their intellectual property and the National Park Service. So the name is now called Digagabimuk, which is really the gift, a word that is a gift from the Penobscot Nation. It didn't start off as Digagabimuk Visitor Contact Station. That word really only came because the trust and the relationships had been put in place to provide a space for thinking about what it means to have Wabanaki culture properly protected within a space that, you know, many people are going to be going to, and the work that it took for all of us to kind of get to that place to have that protection. When we did the benefit sharing as well, and I just want to give a shout out to the Wabanaki Community Foundation, which is one of the first Indigenous-led and foundations that has been created to support Wabanaki culture and cultural health, was a kind of an outcome of the kind of training that we did around, like, well, who does benefit from this building? Certainly the National Park Service does, and certainly the foundations that are, and you know, others that have contributed into it will constantly be referred in the kind of the writing that happens. What happens to the Wabanaki communities? How do they derive benefits from this building as well? And so creating this Wabanaki Community Foundation is a really significant step in that direction. So back to you, Trevor.
All right, thank you, Jean. On the ground, in terms of the legal infrastructure, we have a lot happening within tribal nations themselves. So in addition to doing these incredible projects like what Jane has been working with Wabanaki peoples, we also have tribes across the country developing their own intellectual property systems. Every tribe that I've ever worked with already has a kind of intellectual property. It just hasn't necessarily been codified into a written code. So we have tribes actually putting them into written code that could be intelligible to any lawyer. And there are a variety of kinds of intellectual property systems, right? We have some that merely apply Western IP to the reservation, where we have others that are actually bringing up traditional cultural knowledge, traditional cultural expressions, and finding ways to protect those. Protections for data, cultural privacy, certification marks for artists, right? All sorts of different kinds of things that matter to tribes, and they're grounded in the tribe's local culture and ways of sharing knowledge. So it's an exciting time. We know, thanks to Angela Riley at UCLA, that we have at least 50 tribes that have already codified their intellectual property, and hopefully we'll see many more. One example of this is the Pascua Yaqui tribe on the next slide. Pascua Yaqui has developed a pretty remarkable set of protections, including things like protections for knowledge of histories, details of cultural sites, sacred property like sounds and images and other things that have been appropriated over time, knowledge of uses of plants and animal species, and knowledge of ecosystems, even knowledge of their own language, and providing protection for that, including remedies and penalties if somebody desecrates those or appropriates them. So we have tribes that are actually being quite forward-thinking and progressive in their own legal systems. Now the next step is to find a federal enforcement mechanism to make sure that these are imposed even off of tribal lands. All right, Jane, you want to wrap it up? Oh, I think you might be muted. Maybe I can unmute her. Nope.
Or again.
Jane, can you hear me? Yeah, I think you're muted.
Oh, I'm so sorry about that. Yes, there was a little red muted thing on my screen. Sorry. I don't know what I said, but I'm just gonna kind of I don't know what I'm going to say now. I was saying something like, okay, this is all happening internationally as well. There's so much happening. There's both the kind of like theorizing and kind of what it means to identify what the nature of the problem is, as well as the kind of the practical work of kind of changing the systems and creating different kinds of scaffolding that mean that Indigenous cultural sharing is supported and intellectual property rights are recognized. So much has been happening in Maine, and that's incredible. But I just wanted to end with something that has actually been released today. This has taken 5 years for us to develop the first recommended practice for provenance of Indigenous peoples' data as a standard within the Engineering and Electronics Standard Making Association, the IEEE. This is a global standard, and it means that it starts to affect the building of technology so that Indigenous provenance information is connected to data into the future. And so I just wanted to end with that because it's such a significant, it is the first ever standard in relationship to Indigenous data. And it's about kind of changing how do we create new systems where Indigenous rights are present within them, they are legitimized, and they are also, as Trevor was finishing, protected properly by legislation. So I'm going to finish there. And I think, Trevor, you and I, we have like a couple of minutes for questions before you have to run. I'm going to stop sharing my screen, but just so grateful for this opportunity to share this work with you all.
Okay, like Jane said, we have a couple of minutes for questions. I actually have to run to the airport. Any questions that we would, go ahead.
What about cases where different Indigenous groups would claim the same, I guess, like story or artwork in different ways? So one might say it's prohibited for other people to record it, and other groups may say that it's okay, even if it's stemming from the same thing.
Yes, excellent question. So the question was, what do we do when you have two tribes that maybe have different IP interests in the same item or in the same type of culture? I actually ran into this a little bit. I do quite a bit of repatriation work with different communities in the Southwest, and we tried to return some materials to two different tribes of the same material, but it had cultural contributions from multiple tribes. And we found that one tribe was perfectly fine with this material being available for the public, where the other one felt like it should be completely restricted, right? So how do you deal with that kind of a situation? I don't know if we have a perfect way to deal with that, right? We did try to get the tribes in the same room to discuss what they wanted to do. If there was a way for them to potentially share the material, but then, kind of keep it under wraps in their own community, right? But I think in the end, these tribes have the ability to engage in diplomacy with each other, and they've been doing it for a long, long time. And so what our job is as legal scholars or legal practitioners is to help them develop that diplomatic relationship. And so they can resolve those things between each other and come up with the right rules that will help administer that. The challenge, of course, is, what happens when one side is feeling disadvantaged and the other wants to be able to get things out there into the world. And that does become tricky. But currently we don't have any mechanisms other than copyright to help us to do that. So we're relying on an imperfect tool. But we do know that tribes have ways of negotiating these kinds of things, and we've seen it be successful. So thank you for that question. Yeah.
There you go. I'm gonna say no more questions because you've been so gracious and we need to get longer on.
Really quickly, my name's Corey Hinton. I'm an attorney at Drummond Woodsum, and I'm on the steering committee for this Indian Law and History lecture. And so I just want to say thank you to the law school, Dean Softly, for having us. Thank you to Trevor and to Jane. And just so folks are aware, this is the 5th annual of these lectures, and we're currently undergoing a campaign to endow this lecture so that we can bring national experts, international experts, really is who we just heard from, frankly, to come here to Maine, talk about the cutting edge of this work, which is happening in Maine. And it's important that we're all aware of really what's happening nationally and how Maine is really a hotbed for how some of these things impact, what these amazing people can do around the world. So just wanted folks to be aware of that and say thank you again. Trevor, safe travels, Margaret. Thank you.